So, welcome Anita
Thank
Chopra, specialist solicitor in education law. Very nice to have you. Thank you for doing our podcast. So you practice in education law and you have been practicing in education law for 25 years, is that right?
Yes, I qualified in 2001, having started my training contract in 1999. So ever since then I've been specialised in education law.
And what made you go into education law?
So as part of my training contract, I did it wasn't really a seat in education law per se, but I was introduced to education law as an area, one that I didn't know very much about before. And I just fell in love with it. I found it really interesting, passionate, emotive, but also had a mix of different areas. So like a little bit of criminal law, a little bit of family law, and as the years have gone on, also employment as well, so acting for teachers, where they quite like the sort of marriage between education and employment. So it's all worked really well and I absolutely love it.
So the education areas of law, if I can put it like that you deal with are the same as what I deal with, but obviously you have dealt with education law far more longer than I have, and it's a real honour to have you because of that reason. And also there's not many specialists in education around the country who have had widespread media recognition. So hats off to you, and being a commentator on that basis and being called upon by mainstream networks and speaking. So I think that's really, really commendable.
Thank you.
So one of the things I'd like to discuss with you is the different areas of education law, which I think a lot of people don't really understand or know. When they hear education law, they think, what do you deal with?
Yeah. So
let's deal with the university type of challenges that are out there. I find that a lot of students nowadays are using AI, which is landing them in a bit of bother. And because of that bother, plagiarism is being alleged against them or something along those lines. What's your experience?
Yes, I mean, I think prior to AI becoming really, much bigger now than it was before, but then there used to be, which I think is still around, a software called Turnitin, which they also used to use, universities used to use in order to identify and decipher if somebody's work had been plagiarized or hadn't been footnoted accordingly. So yes, I mean, the issues and cases of academic misconduct, I think, are on the rise because of AI. There were issues before, whether that was to do with a lot of extenuating circumstances, but also I think plagiarism, a lot of the students that I would act for, it was because this software would end up identifying things that they may not have footnoted properly. So it wasn't necessary, obviously it wasn't intentional, but they still unfortunately ended up having to defend a case of plagiarism.
So the OIA that deals with complaints from students about various downgradings, etc., discrimination, I think as well they deal with from memory. I can't remember exactly the remit. So do you find that sometimes going to the Ombudsman is actually a fruitful choice, if I can put it like that? Because my feeling is, like any Ombudsman, they can only do a certain amount for the complainant.
Yeah, I think that's absolutely right. I think it depends on really what it is you're hoping to achieve as an outcome. So often the outcome isn't something that the Ombudsman can offer you, and also the time delays. Sadly, the Ombudsman necessarily does take 12 months, sometimes longer, to come to a decision, whereby the court, things can be expedited. And again, it depends on the severity. If it's breach of contract against university, for example, you wouldn't necessarily go to the OIA. So I think it depends on, the cause of action depends on really the outcome that the student's looking for. And then it's important to gauge which outcome they should follow as a result. Sometimes, obviously, because it's financially, it's cheaper to go to the Ombudsman, and therefore some people do take that route.